Welcome everyone to our webinar today. I'm here with Deborah Burke. Hello, Deborah.
Hi, Mena.
The webinar today is about improved profitability. We are specifically talking to Deborah about civil work today, but we are going to mention the cross-reference to other areas of law. If you haven't used the GoToWebinar software before, you are able to ask questions. Only I will be able to see the questions to start off with. I'll read them out when it's appropriate and Deborah will answer those questions. Deborah's email address is at the end of the webinar, so if you've got any specific costing questions that she can only answer by emailing you, then obviously email her, or I'll pass her question on and she can contact you back if it's too complicated to answer on air. Deborah is a non-practicing solicitor and does lots of interesting work with the Law Society, which she is going to tell you about. So I'll hand over to you, Deborah, so that you can explain to our listeners exactly what it is that you do and where we're heading in terms of profitability.
Excellent, thanks, Mena. So what I thought I'd do first of all is just to give you a bit of background about why I am enlightened about time recording. I was in a meeting with Andrew Day a couple of years ago. He's the head of operations at Barclays, and for reasons that we'll come on to in a bit, I was listening to him talking to me about e-billing. And I wasn't particularly interested in what he was saying. Barclays is a vast consumer of legal services. Most of their work is non-contentious, and he was chatting on about how they use e-billing and why they were so keen on it. But he said something that kind of caught my attention. What he talked about was the e-billing process, where the time recording that the fee earners do for Barclays, they're outsourced, obviously their legal work to lots of different firms, appears automatically in the e-bill, which is subsequently delivered to Barclays as the client. And what he explained was that they can investigate that time recording and drill right down from the high level summary figures of the amount they're being asked to pay, right down to look at who was doing the work, when they were doing it, whether they were working late, early, at the weekend. And that really kind of hooked me, because it was the first time that I'd actually heard anybody talking about time recording in a different way. So other than using time recording just to check that someone was in and doing something that was hopefully chargeable. And that really is sort of where I became more interested in time recording as a way of increasing profitability. He also referred to the write once, read many phrase, which you will see sometimes when people are talking about time recording, and the benefit of that is that you capture the information once, but you use it for many different purposes, and that's both client and solicitor. And he also talked about systematic time recording, which we're going to look at today. So that's how I got to be enlightened about time recording.
Fantastic. And of course, that's time recording generally. You're going to be speaking today about cost management specifically with regards to civil work, but there's no reason why a lot of the things that we're talking about today can't cross over to different areas of law. And as we go through, I'll let you explain how that can work.
Absolutely. And in fact, the next slide really explains why we were talking to Andrew Day in the first place. Many fee earners will have heard of the Jackson report. It was delivered quite a few years ago. Lord Justice Jackson was really looking at controlling the cost of civil litigation, and he made a couple of recommendations which are important for us today, looking at time recording. First of all, he recommended the introduction of a cost management regime. What he wanted was to be able to manage the steps in a case and the costs incurred to make sure that the legal spend was proportionate to the issues at stake. And he recognised that with that, you would need to have an approved budget, something you could spend on the case, and you'd need to be able to compare that to your actual costs at the end of the case really easily in order to make sure that parties weren't overspending. That's really quite well known now. But the other thing that he talked about, which is relevant to us, is that he looked at the bills of costs that are traditionally exchanged at the end of a case, or sent by the receiving party to the paying party at the end of a case, and he thought that the whole system of manually creating bills of costs was really expensive, really cumbersome, didn't make use of any technology. And he was, I suppose, mindful of the fact that in many firms, even today, time recording starts with a handwritten note, or it might be typed into a system. At the end of that, it is of the case, it's sent off to an external person or maybe a junior member of the department. They then have to read it, they have to maybe retype it or dictate it, it has to be typed again. Then it has to be checked by the original fee earner, and all of that happens, and there's a time cost to that. And he thought that an electronic bill of costs should be developed for civil litigation cases, which would be much cheaper, would use technology in a smarter way, and could be created, transmitted and analysed electronically. So they're the two things that he said which are really important from the perspective of time recording and being better at what you do and more profitable. If we just move on to the next slide, Mena, this
who's
really
that?
just...
Deborah, who's that chap at the top of the slide?
Oh, that's Lord Justice Jackson.
Ah, right, okay.
Yes, well known, but not necessarily well liked.
Surprising that he's sitting there with lots of paper on his desk when actually he's talking about electronic billing and bringing everyone into the 21st century finally.
Absolutely, yes, you're absolutely right, and it's surprising actually, I suppose, how paper-based we all are now, even though we think that we are much better at dealing with things in a paperless or paper-light way.
Yeah.
Thanks for moving on to this slide. So this just really summarises very briefly the involvement of the Association of Cost Lawyers. So as well as being a non-practicing solicitor, I'm a cost lawyer as well. And I chaired a committee which delivered a report in 2011, which looked at what Lord Justice Jackson had said about time recording and about cost management. Specifically about bills of costs, we thought that it was really significantly interesting that firms could start to use electronic data straight from their practice management system. We realised that, you know, as with all time recording, you need to have really good time recording going in to a system in order to get the best use of it coming out the other end. So it needs to be good and specific enough. We looked at the categorisation of time by phase, task and activity, and we're going to look at that again in a minute. But one of the things that Lord Justice Jackson did when he talked about recommending cost management was he said that a case should be broken down into chunks of work by phase. So the different elements of a case should be broken down by phase, and that's how budgeting is going to work. We also looked at phase, task and activity, and we spent a long time thinking, should we try to start again and invent completely from scratch a way of time recording systematically that would work with budgeting by phase, task and activity, or should we try to borrow from something that already existed and adapt it? And we decided that it would be better to borrow from an existing system of coding and adapt it for litigation in England and Wales. And so we decided in our recommendations that it would be better to look at the UTBMS system of time recording, which already exists in many, many practice management systems in this country and particularly in the US, and adapt that for UK litigation. So that was the Jackson report, or the ACL's take on the Jackson report. What Mena's brought up now is Precedent H, which we see all the time in the cost managed world that I operate in. It is not to be confused with the Form H that family lawyers will use and be familiar with in terms of their estimates for family cases. It is a completely new form. If you look at it from left to right, on the left-hand side, you can see the phases of the litigation. So these are the main chunks of work within a case, in a civil case, which is cost managed, right through from pre-action at the beginning to trial at the end. In the middle, coloured yellow, there is a section for the fee earner to put in assumptions about the work that's going to be done, to show the judge what's anticipated and what's not anticipated. And on the right-hand side, there are, in a completed Precedent H, a whole pile of figures. The left-hand set of columns, which says incurred, shows the judge what's already been spent in the case at the point when the budget's prepared, and the right-hand side set of columns shows the judge what the party would like to spend going forwards, and then there are totals. This is the top page of quite a long document, but this is the summary of everything that goes into a budget. The rules for cost management say that if you have a multi-track Part 7 claim and it's worth up to £10 million, then you need to file and exchange a budget in this format. But interestingly, and you and I have talked about this before, the practice direction for cost management sets out some other types of litigation where it thinks that a cost management process might be particularly good. And two of those can apply to family lawyers. The first is Trust of Land and Appointment of Trustee Act cases, and the second is Inheritance Act cases. So the rules envisage that cost management might be particularly useful in those two sorts of litigation, as well as the typical multi-track litigation.
Because, I mean, in terms of, I'm a family lawyer, as you know, Deborah, it's not too unusual to break down a case, perhaps not into these exact types of work areas, but we certainly have pre-action costs. It seems like a sensible idea to be able to predict costs going forward. But I can imagine that family lawyers would be very resistant, as I'm sure civil litigators were, to this type of introduction of cost budgeting, particularly if we were going to be held to that, because so many things happen that are unforeseen. That how could you be held to a costs budget at the beginning of a case?
Yeah, I mean, you're absolutely right. And actually, although this form doesn't really give you very much space for the assumptions in that yellow middle section, when we're preparing budgets in civil cases, the assumptions will be a very chunky document, and it will be a combination of high-level assumptions, which would be the main outline of the case. So do you think it will be defended to trial or final hearing? You know, how many witnesses you think you'll have, how many experts might be involved, what you think the disclosure process is going to be like. So the kind of real, you know, high-level structure of the case. And then we also provide our solicitor clients with phase-specific assumptions. So what we think within a phase, the main tasks are going to be.
Okay.
Do we think they're going to have to do, you know, various stages of disclosure? Will it be simple, complicated? And critically as well, we also spend time with our solicitor clients working out what we think isn't going to happen. And we call those negative assumptions. Okay. So, you know, we're trying to build up as comprehensive a picture as we can, because you're right, what happens here with an approved budget is that that acts as an upper cap on recoverable costs, unless you can persuade the judge that you should be allowed to get around the rules, and that's very hard. But within that, what we're looking to do is to show the judge exactly what the roadmap is we think the case is going to go along. And then there is a procedure in the rules. If your case goes off track, so it doesn't follow that roadmap that you've designed for it, you can revise your budget, but you've got to be able to show where it's gone wrong, why it's gone wrong, and what you need to do to put it on track again. So that's why assumptions are so important.
So before we move on to the next bit, is it something that is working? So is this cost budgeting working? Is it being accepted?
In the sense that it's mandatory, yeah. I mean, people are working within it. Yeah. How easily people have adapted to it, to some degree, depends on the type of litigation they're involved in and how good they are at project managing their cases. You know, fee earners who are good at project management, who understand how to construct a case in terms of likely steps, who've got the experience to know where it's likely to go, where it might go wrong, they tend to be better at scoping a case. Fee earners who are maybe less organised, less experienced, they are struggling sometimes, but then in our world, that's what we're there for. You know, we're practicing solicitors or non-practicing solicitors now, and we've got great experience in helping people to construct their templates for a case. It's not popular, and some of that has been because it was introduced, even the way that Preston H is designed hasn't really been thought through necessarily. So there are changes that could be made to make it more workable, and it's also, I suppose, from my point of view, people like clinical negligence practitioners have been budgeting for a lot longer than some of the commercial litigators. And as they get more used to it, they get more familiar with it, and it works better for them.
Sure. Great, thank you. So moving on to the progress since the Jackson report, Deborah.
Yes. So we have the Jackson report, we have the ACL reports, we have the introduction of the cost management regime. We then had the initiation of a committee, which is currently chaired by Alex Hutton. He's a cost QC. I'm on that committee as well, and we've been spending time developing that new type of time recording code, now known as the J codes, and we've also been looking at a new format for bills of costs. In terms of the J codes themselves, we took the US system and we adapted it for England and Wales, so we don't have things like depositions, we have witness statements. And that has now been signed off a year and a half ago by a senior judiciary. It's been approved by an international committee who deal with UTBMS codes worldwide. And what it does now is it gives fee earners in the England and Wales jurisdiction the capacity to time record work contemporaneously using codes which are compatible with that precedent H that we just looked at.
Okay, that's great. So then these J codes, I know that we've got a handout in our handout section, and you've kindly given the delegates who are live online today a copy of a PDF, which is your crib sheet. That's right, isn't it?
Absolutely, yes. I mean, so what this slide gives you is the web reference for finding the codes themselves. The codes are within a document that you can see a picture of the front cover on the right hand side of this slide. It's a really long document, it's about 49 pages long, I think, all very well written, but if you want to just see the main points, pages 9, 11 and 12, 20 to 22 and 23 to 26 give you an idea of how they map to precedent H, a summary of the phase and task codes, same thing with the activity codes and the same thing with the expense codes. So if you just want to dip in and have a quick look, then I would suggest that you look there. And our crib sheets, which we've used for our clients really, because it's a big step for clients to use a different sort of time recording. So they're there for our clients to put on their desktop, use them when they need to until they're confident that they can remember which codes go where.
It's one of those things that you pick up as you go along, isn't it?
Oh, absolutely. And in fact, if any of the people listening at the moment are old enough to remember the old legal aid codes, we memorised quite a number of codes back in the day for legal aid claims for costs. And it's not as hard as you might think. There is a certain amount of getting used to them, but it's certainly perfectly doable. And over time, you get more and more familiar with the codes that you use most often. Most people don't actually go to trials anymore, so they are less likely to need to access the trial codes and the prep for trial than they would be to know the codes for example, disclosure, witness statements and expert evidence, because they're the ones that you will use a lot.
It's worth mentioning that if you've not used the software before and you're listening today, there's a section in your box that says handouts. You should just be able to click on the J-Codes crib sheet and the course notes handout and download them onto your desktop. And for people who are watching this as a recording, they can email you and you can send them the J-Codes if they want to have them afterwards. So you can only download them live now. And for people watching the recording, you can contact Deborah. We'll have her contact details at the end of the webinar, and I'm sure she'll be happy to send you her crib sheet.
Absolutely, yeah, that's no problem at all. What we've got on the next slide is just an example really of how J-code time recording works. I often get asked to explain how it works because it is a different way of thinking. Historically, when fee earners time recorded, and I certainly did when I was in practice, I'm sure you're the same, Mena, what I used to do was carry out a task, I used to do something, and then my time recording would be driven by the type of thing I'd just done. So if I'd made a phone call, that would be how I would start. I would say, telephoning whoever. Then I'd give a bit more information, and I'd stick the time that I'd spent, and that would be how I'd time record. The biggest change if you're going to use J-codes for time recording is that you start the other way round. So you work out, first of all, which one of those main phases of the case you're working on. And in this illustration on this slide, I've assumed that we're looking at witness statements. So first of all, you think, what have I just done? Oh, I've been doing something to do with witness statements. So that allows you to identify the phase you're working in. And then the next thing that you need to do to time record it is to decide which of the tasks within that phase you're working on or you've just worked on. It's quite a granular process using J-codes. They're quite chunky, so you don't have to make many decisions. In the witness statements phase, you've just got two choices of tasks. One is, are you working on your own witness statements? That's JG10. And the other is, are you working on the other side's witness statements? So that's the only decision you have to make. And if you look at the coding, JG10 tells you two things. It tells you the phase you're in, that's JG, that's witness statements, and 10 tells you that you're working on your own. Same thing with JG20. So you're in the witness statements phase, and 20 means that you're dealing with the other side's witness statements. So once you've established that 4-digit code, and there are only two choices, it's either JG10 or JG20, you then have to look at what activity you've just undertaken. 3 are on that slide. There are actually about 16 that you would use typically, but they're divided into 3 groups. And if you get a chance to look at the crib sheet, either now or at a later date, you will see that on our crib sheets we've divided the activity codes into 3 main groups, which makes it quite a lot easier to do. And again, with practice, you will find that you are using the same codes all the time and then other codes only occasionally. So something like drafting or revising you will probably use a lot. Communicating with your own client, again, you'll use that a lot. Communicating with the other side. So you will very quickly be able to pick up the ability to get at least phase and task and probably most of the activities stored in your memory, and you can use them from memory. If not, you can either use the crib sheets, the sort of thing that we've got here, or you can, if your time recording system, and we'll have a look at that in a minute, either is already J-code compatible or could be J-code compatible, then you can be guided through with a good time recording system so that you have to make very few choices in order to get your time recorded.
Because I can see that it would take a little bit of sort of brain changing to get around the fact that you're not just saying, you know, drafting witness statement. Instead, you're saying witness statement, whose witness statement. But I guess once you get into the swing of things, it's pretty straightforward. I suppose the complaint is going to be it's going to take longer in the beginning.
Well, that's right, and it's funny you should say that, because on the next slide, I've given a small illustration of, you know, whether or not it will take longer. Again, it's the question that I'm often asked when I'm speaking about J-codes. You know, it will take much longer. You hear all sorts of horror stories about A, how many permutations of the codes there are, B, how long it will take. I've given there 2 examples. The first example, drafting work to expand client's witness statement to deal with continuing losses because premises remain closed. Now that's a kind of typical old-fashioned traditional time recording entry. You would have a time as well for that, like 10 minutes, 12 minutes, whatever. That's 112 keystrokes. So if you're typing, that's 112 characters and spaces to get that information into your time recording system. If you've got a J-code compliant time recording system, that's brilliant. You're going to be much quicker using J-codes. But say you haven't, and you need to type everything. So you need to type both the J-code at the beginning and some more information. So the second little statement on that same slide is what you would probably type if you had used J-code. So you type JG10, so JG witness statements, 10 your own, A103 is drafting, and then you put a bit more detail. The only detail that you'd need to give as much information as that first entry. Now that's only 83 keystrokes. So actually, it's 25% fewer keystrokes. If each keystroke takes you the same amount of time to deal with, then you should be 25% quicker. You will not be as quick as that when you first use them, because you will need some time to get used to them. But you can see that as soon as you are more familiar with them, there's no reason why the actual amount of typing wouldn't reduce. And if the typing reduces, the time reduces. And not only have you got that, you've got your best shot at time recorded contemporaneously, and we will look in a minute at how you use that going forwards for different purposes.
Deborah, someone's just commented that it would take them 15 minutes to figure out what the JG10 A103 code was for before they got to the point of recording it. So I think that's what you're saying, really, isn't it? That at the beginning, it's not going to be as
absolutely
quick.
Absolutely. And I think you know, if you had something like our crib sheet up on your desktop on your PC, and you start to think about what you're going to do on witness statements, open up the right sheet, and then you've got the two choices there. So actually, it is more a procedural change. It's certainly not something the fee earners aren't capable of doing.
Yeah, no, I agree with you. It's just a matter of getting used to something new, isn't it?
Yeah, absolutely.
Okay. So moving forward then.
Yes, so the next few slides are, you mentioned at the beginning that obviously most of our work is dealing with cost managed cases, and this slide looks at what happens to time recording that's been done with J-codes and how civil litigators use that time recording data. So as long as, and it is a big caveat, as long as the time recording is of sufficient quality, so it's the same as now, you need to put the right stuff in. If you put garbage in, you'll get garbage out. But as long as it's of sufficient quality and it's accurately done, then civil litigators no longer need to reinvent the wheel. So when they've time recorded time spent on a cost managed case with J-codes, then that means that when they're constructing a draft budget to go to court to ask the court to approve what they would like to spend in the future, then the incurred work that they've already done, so the work that they've done before they constructed the draft budget, that goes straight into the draft budget and is calculated automatically. At the moment, when we are dealing with a cost managed case and the fee earner hasn't used J-code or phased time recording, we have to manually take every single time entry, and it might be 5 years worth of work, and allocate it to a phase in the budget. That's extremely expensive, very time consuming, and it clogs up the system. With J-code time recording, that information is there instantly and it goes straight in. So that's a first big difference for civil litigators who are using J-codes. They're also able to monitor their actual spend much more easily. If you live in the civil litigation world, you will have heard, I'm sure, horror stories already of people going to court with a good budget. They get their budget approved. The figures might be adjusted, but they're there and they're approved figures. They come home, stick the budget which is approved into a filing cabinet, they never look at it again, and they've no idea whether they are under budget, within the budget, around the budget, or they've wildly exceeded their budget. Now if you J-code time record, you are able to see daily, if you need to, how you are doing against your approved budget. And something that may not have been completely obvious from that precedent H slide that we looked at a little while ago is that the approved budget is by phase. So you get an approved amount for witness statements and an approved amount for expert evidence. You can't borrow from one to the other. So it's really important that you're able to monitor your phase spend accurately, and using J-codes allows you to do that at no extra cost.
It's surprising to me, Deborah, that you would, as you say, come back with your approved budget, stick it in a filing cabinet and never look at it again, particularly when you know what the consequences are of exceeding the budget.
Absolutely, and I suppose, again, it's an example of a system that's been imposed on litigators and they're not necessarily very comfortable with it. So we have seen cases in our business where the first time that anybody's looked at the budget is when they've already won the case, and it's too late then. Some research was done a while ago by one of the major costing businesses, and I think they found that in more than 40% of cases, at least one phase was significantly over budget. In budgeted cases, I think we analysed about 1,000 cases. So we're talking about a real problem for litigators. And actually, when they're under pressure to get a result on the legal work, what they really don't want to have to do is to manually check how they're doing on costs as the case progresses. They want to be able to concentrate on the stuff that they're brilliant at, which is getting the result for the client. Costs claimed against the budget comparison. So that's, I suppose, what happens at the end of the case, in the same way that you can monitor easily during the lifetime of a case. You can see at the end of the case very easily whether you are over budget on one or more phases. And that allows you at the first opportunity with your client to decide what you want to do about that. Are you going to try to show that you should be able to exceed your budget? Are you going to concede any overspend? Is there anything that you can do to make that outcome better for you? So again, if you've time recorded with J-codes, that process is there and you can do it immediately. Moving on to the draft bill of costs, which was the, sorry, if I can just go back to the previous slide. Sorry, Mena.
Sorry.
The draft bill of costs that has to be produced at the end of the case when you've won. You also can get your data into that draft bill of costs much more easily if you've got J-code time recording. Precedent H is something that you will only know about if you're a civil litigator. That's a weird little breakdown of costs that you have to serve at the end of the case with your bill to show how you've done phase by phase against budget. And again, that can be prepared at very little time and cost if you've already got J-coding. And the last thing that civil litigators are already seeing as a benefit from using J-codes is that they may well have some interim applications that they deal with along the way. The cost of those can be easily collated and assessed if necessary at the end of an interim application. And again, that's very much easier with J-code time recording than it is if you're doing traditional time recording. So that's really where civil litigators are seeing the benefits already of J-code time recording. On the next slide, I've got just some sort of the other benefits that civil litigators have when they've used J-code time recording. It's obviously cheaper. I mean, we've mentioned several times that you don't need to repeat time recording more than once. So it goes in once, it's accurate, it reflects what you've done, it's in the right phase, it's in the right task. That means that you're not having to pay either a member of your team or an outside cost person to quantify your costs for you. You have the capacity to have more efficient cost negotiations. I'm always telling my clients, if you can get an inclusive deal which includes recovering your costs, then do it. And you're much more likely to be able to do that if you've got information about cost at your fingertips. So if you're going to a mediation, if you're going to a JSM, in a cost managed case, and you've got up to the minute information about your costs, you can see that you're not over on any of the phases. You can show the other side what you've done for each phase. You are much more likely to be able to get an inclusive deal. If you get an inclusive deal, you don't even have to do a bill. You get your money in more quickly, and you can move on to the next case. Enhanced analysis, that I suppose really takes us right back to the meeting with Andrew Day and his use of information about time recording. So the client will often like the fact that they can have more information about how the costs that they're paying have been arrived at. But actually, firms can use data which is systematically time recorded to do a number of different things. They might want to look at fee earner performance. And we see it all the time on cases where we act for a firm or a department. They've got a number of different fee earners, but the fee earners spend dramatically different amounts of time carrying out basically the same sort of tasks. So they can look at how fee earners are performing, they can look at where they're effective, where they may need some training, how they compare to other fee earners. They can also use information about the time that they take to carry out parts of a case to improve their estimating. It's one thing relying on, finger in the air or someone else's idea of how long it should take you to carry out a specific task, but if you've got your time recording systemized, you can see across your fee earners, across your clients, how long you typically take to do things, and that will make it easier and better for you going forwards if you're constructing cost estimates. And crucially, and again, this is probably something which is very much in the mind of civil litigators at the moment, if you're required to offer a fixed fee offering, either because the courts are stopping you recovering discretionary costs and they're saying you can only recover fixed costs, or because your clients are requiring fixed costs in order to come to you and place their legal work with you, it's a lot easier to develop a fixed cost offering if you know what different chunks of the case typically cost you and where the significant costs in a case lie. All of that is easier if you are time recording by phase and by task, but certainly by phase rather than chronologically. And I suppose lastly, I've stuck it on the end of this slide, it is the easiest way of ensuring that whenever an electronic bill of cost comes into the civil litigation arena in the future, whenever that is, that you are ready to go and that you can construct those bills of cost in the most time and cost efficient way.
I mean, it's worth noting in regard to fixed costs you mentioned there, Deborah, that it's not just in civil litigation that the courts are being quite persuasive about offering fixed costs, because I think across the board judges are saying we should, as lawyers wanting more work, better work, all be offering fixed costs to our clients. And the only way that you could do it, as you say, or the best way to do it, the most profitable way to do it, is to use this kind of time recording system.
Absolutely, and I think from the point of view of clients are really interested often, especially in the commercial world, in knowing how their cost estimates have been constructed, and it enables you to have what can be quite difficult conversations with clients about cost in a more objective way. So I've never had to go through a divorce, but if I could see the cost of the different stages of my divorce work, and if I could see that a contested final hearing would be very expensive for me, that might help me to have a better handle on what I'm likely to have to spend. I can agree a fixed fee with my solicitor, know exactly what it covers, see how the costs are building up. I think I would like that. And I think many consumers of legal services, whether they're businesses or individuals, are really keen on that. And I think as a matter of good practice, solicitors should get better at providing really accurate estimates of what they are likely to charge. If they can do that, then they can offer fixed fees. And in the commercial world, for some time, there have been firms who are really innovating and going out there with good fixed fee offerings for part or all of a case, and they are doing that with some real certainty because they've done the investigation beforehand. They know what it costs them to do that work. And you've moved on to the next slide, which is showing really what we're talking about now. You've got the same benefits that you would have if you're a civil litigator. So if you're engaged in a different type of legal work and you're using something like J-codes, you've got reduced costs, you've got efficient cost negotiations, enhanced analysis, building a fixed fee offer we've just been talking about, using client-facing budgets, and I suppose that's what I've touched on just now. That's something that we are seeing a little bit more in the civil litigation world, which is that the client gets a budget as well as the paying party or the other party in the litigation. That enables clients to have conversations about how their costs are building up, even in a case which isn't going to be cost managed. And clients certainly are very open to seeing more information. It's much easier, in my experience, to show a client how you've arrived at a figure for costs if you can show them what you think is going to happen. and what you think isn't going to happen, because then they can understand why your figure is, if it's £10,000, why it's £10,000. It's the kind of example we often give in personal injury cases, is that if you make an assumption in a case that you're not going to be served with surveillance evidence just before the trial that shows that your client isn't actually always on crutches, they're off at a yoga class or doing aerobics, then they can see that if you suddenly are served with that kind of evidence, it's going to make your costs a lot greater. So that you can have conversations about cost and show clients where they can save money, where they'll spend more. Again, it's not, in the family world necessarily, but we often see with civil cases, if there are things like large amounts of documents to be reviewed as part of the disclosure process, there are different places in the world where that task can be carried out. Different jurisdictions, it could be cheaper somewhere else to do it, but there will be risks associated with it. All those conversations are much easier when you can show a client the anticipated cost for a phase and then a task within a phase. I hope that makes some kind of sense. I know I'm going through a lot of material in a short space of time at the moment.
No, it's perfectly straightforward. I think the problem for non-civil litigators is trying to envisage all of this coming about, and how firms are going to be able to adapt to that, and whether they would adapt to it unless it was mandatory. And I think that firms would be increasing their profitability, obviously, but I think you need to be forward-thinking enough to implement these types of systems first. So as you say, it's a holistic approach. You need to want to offer fixed fees and be more profitable rather than stick with hourly billing and hope for the best, really.
Yeah, I think that's absolutely right. And if we just move on to the next slide, that's really a reminder of why costs are so important in that solicitor-client relationship, and doing business is increasingly about maintaining those relationships with clients. The SRA Code of Conduct requires solicitors in every area of legal work to give the best possible cost information at the beginning when the engagement takes place and as the matter progresses. And that's about the likely overall cost. And I think it's much easier to estimate overall cost if you can estimate the phases within the case first, because you're building on something that is more systematic. And you can also have discussions with clients about, for example, the effect of the contested final hearing. So in something like a clinical negligence case, often 40% of the total costs will be wrapped up in the pre-trial and trial phases, yet 98% of cases don't go to trial. So that's a really important point that you need to get across to clients, and the Code of Conduct requires you to give the best possible information, not just the sort of information that you might have seen a few years ago, which was in the retainer letter, something which said the cost will be between £10,000 and £50,000. Because for an ordinary client, that margin is just too big to be of any real help.
Yeah, but those are, from an hourly basis, in terms of family billing, we're still giving ranges of estimates, because it is broken down by phase, but you just never know how much it's going to cost overall.
Absolutely. And in fact, something that we've seen for a while now in commercial cases is that the client and solicitor will move through a variety of different sorts of retainer arrangement and fee arrangement depending on the stage that the case is at. So you may well see in a commercial case that a solicitor will feel confident offering a fixed fee to start with. So they will say, for the pre-action work, we will offer you a fixed fee. And then they know that that's what they will have to do, and the client will pay no more than that amount. It may then be that when there's a conversation at the end of that pre-action work about issuing, that the client or the solicitor says, well, for the next chunk of work, it will be by the hour. It could be subject to a cap, so that's a mixture of how long it takes, but no more than X in any event. And then you might find that that there is a CFA in place for a while. That might change again. So that kind of sophistication and that kind of flexibility, I think, is really important for lawyers going forwards, that they can offer different arrangements depending on how they feel about the client, how they feel about the client's case, as well as how the client wants to do business.
That's great. I think that this is something that we really all need to take on board. We know what the Code of Conduct says, but the way you interpret the code is very different from firm to firm and solicitor to solicitor. But it's worth bearing in mind that this is a professional requirement to ensure that costs are properly set out and clients understand, and the types of clients that we deal with are not sophisticated. They're not companies, they are individuals, and I think they need a little bit more hand holding through that process.
Absolutely, I think you're right, and I think you'll probably know more about this than I do, but in terms of client complaints, often it's not the quality of the legal work that causes the complaint. It's the way that the cost side of it has been dealt with. So it's not that a poor result was obtained or that the work wasn't done well, but if the client has a misunderstanding about what it's going to cost them to get that result, they can become disillusioned, they can become a grumpy client, they may not come back to you in the future, and that's not good business. And if anything can be done to make that better, then I think that's a good idea.
Yeah, it's also worth mentioning that we did a webinar with a complaint specialist before Christmas, which is available on our website and our YouTube channel, going through complaints and common causes for complaints. And you're absolutely right that the failure to explain things in a way that the client can understand them with regards to costs and timing really, really important. So if people are interested in that, then that webinar is free and it's available to view on our website or our YouTube channel. So we're coming towards the end of the webinar. I just want to remind delegates that if they've got questions, now is a pretty good time to type your questions into the question box, and I will put those questions to Deborah after this slide, which is her last slide for the webinar today.
Yes, so this really is just setting out three things. If you're serious about improving profitability and you want to get your time recording in better order, there are three things to consider, investigate and plan at this stage. Look first of all at whether your time recording system or your practice management system can actually record by phase, task and activity already. Although you may not be using it, it is built into many, many time recording systems, including the ones that are most popular with lawyers. So it may already be that your system can facilitate you recording by phase, task and activity, or at least by phase, because that is a sort of halfway house. If you can at least get your time into the right phase, even if you can't give more information easily directly into your time recording, then that's the first thing to find out. Second thing to have a think about is whether or not J-codes already work for your area of expertise. So they are designed to be of the most kind of general application for civil litigation. We had, as part of the consultation on bill format, I think it was the Treasury Solicitor saying, can we have our own codes for judicial review? And we said, brilliant, however you want to time record, that's great, but there may be ways that you can tweak a standardized coding system so that you can include that structure of phase, task and activity, even if you're not using all of the J codes. And in fact, in our business, we are moving over to time recording our work by J code, because it would seem hypocritical and extreme if we weren't doing it, as we're advocates of doing it, of fee earners doing it in the legal world. So again, we will be adapting the codes so they suit us better, because we don't do everything that fee earners do in the main litigation, but we have certainly phases of work that we do and tasks within that, and we're going to be moving on to that. So for solicitors, doing the same thing is a good idea. Have a look at the J codes, have a look at whether they work for you, and really think about what you want to get out from the data that you gather. Again, I suppose traditionally solicitors haven't looked at that time recording data in the way that we're encouraging them to look at it now. So typically you would use time recording just really, I suppose, to look at WIP building up on the, within the department or the firm, look at how many chargeable hours a solicitor does or a fee earner does every day. But if you are able to think about the cost of different chunks of work, if you want to compare how different fee earners work, think about what you'll need to analyse and make sure that how you time record will give you that information in its raw form that you can then analyse. They're probably the three things that I would suggest people look at first of all. I mean, by all means, chat to me, chat to one of my team. We see a lot of firms who are undergoing this process at the moment. Some who've gone through it completely and are completely happy with what they've done, but lots of people are thinking about practice management systems, thinking about becoming more systematic, and if we can help in that, then feel free to make separate contact with me.
That's fantastic. Thanks very much, Deborah. That's all been food for thought, I'm sure. We haven't had any questions coming through, so I'm just going to wrap up the webinar and let people know that they can get 50 minutes CPD if they are solicitors and they're still using the hours-based training regime. Then this webinar is worth 50 minutes of training for this year. There aren't any codes that you need, you just need the title of the webinar if you want to record this for internal purposes. And of course, if you read through the handouts and if you have a look at Deborah's J-Codes crib sheet, then it may be that you can claim a bit more time in terms of learning and development. And if you've got any questions that you didn't ask during the webinar, then by all means contact Deborah. I've put Deborah's details up on the screen, so you've got her email address, the website address. Of course, she's on LinkedIn and Twitter, so you can contact her in any way that you want to. We've got a little bio for Deborah so that you know who she is, and of course, if you want to take this opportunity to download the notes and the crib sheet, then it'll take you a couple of minutes to do that. And finally, a little bit about me and the training company that I am a director of. And we offer training for solicitors firms across the board, across the country. So if you do need any further training, specifically with regards to the new competence regime, then please do contact us and let us know. So finally, Deborah, I'll just say thank you once again for joining us today for the webinar. It's really been hugely interesting, and hopefully people who have additional questions will contact you directly.
Thank you very much, Mena.
Thank you very much. Thank you everyone for attending today. Goodbye.